Good afternoon. My name is Mamal Chadha, and today I'm going to talk about law account confidentiality in the light of emerging technologies. Uh, Confidentiality is an obligation owed by the lawyer to his or her client, enforceable via the disciplinary systems of the common law of equity and contract. Over the years, lawyers have used available technologies to communicate with the client. This include faxes, cordless telephone, and recently internet. Okay, no authority exists which suggests that privilege is unavailable simply because a lawyer and a client communicate via internet or email. So the confidentiality of the law is a key aspect of the legal profession. The use of information technology has the potential to impact this confidentiality in Australia. The ethical rules governing the law-client relationship, including the obligation to maintain client confidential, are set out in the Legal Profession Uniform Law in Victoria and the Legal Profession Uniform Journal rules. Now, so we talk about the rule. Here is one of the rule which basically says that, in advertent disclosure, it says, unless otherwise permitted or compelled by the law, solicitors to whom material known is reasonably suspected to be confidential disclosed by another solicitor by such other person and who is aware that disclosure was inadvertent must not use the material at all. So one of the important information when we talk about electronic communication is related to the metadata. So metadata has three different types. Metadata for, okay, the first is that data is generated and stored in a document by the software used to create it. Let's say if I'm trying to write a letter to my client using a Microsoft Word, so there will be one metadata created by the Microsoft Word. And the second type of the data will be me as an owner of the PC or the software subscription. That will be metadata will be created under my name. The third will be basically if there is a linkage between one software piece to another piece of software as well. So this is basically some of the important things, okay, to know for the lawyers. So there is a responsibility for both the receiving lawyer and basically sending lawyer. So both need to give information. They are only sending information which they are authorized to. However, in case the receiving lawyer, if they receive information which they're supposed not to be receiving it, they're supposed to be letting the person who's sending it immediately. And okay, now, so one thing is the lawyers need to understand that the metadata include information about how, when, where, and by whom files were edited or created. Metadata has many useful applications. It can be used to locate relevant document easily, especially if there are inconsistency in the document. However, metadata can be dangerous and it may be inadvertently release the information regarding the matter. And an example of this one is the case of Teddy Mine case. In this case, Papua New Guinea was operated by BHP Polytechnic. The mine was found to have polluted the nearby river, and action was brought against the BHP. Following the commencement of that action, a piece of legislation was passed by the government of Papua New Guinea, which made it criminal offense to sue BHP for polluting the river, and also it made it offense to assist anyone who is basically sought to bring such an action. However, it was discovered that through the metadata, it was BHP lawyer who drafted the legislation. As a result, BHP was charged with being in contempt of court. Following that, BHP decisions to settle the issue out of the court for undisclosed importance. So that's reflect that how important it is to basically, how important this one is to basically have the metadata. At the same time, while we're talking about metadata, another important things, challenges which the lawyers needs to be aware of the use of social media, and also the client, and it's the client responsibility that do not share any information through the social media platform. That because if they do share it on the social media platform, that might take away the privilege associated with the client lawyer privilege. And this is an example. There is an example of was a Universal Music Group case in USA where the person have shared his communication with the lawyer in his blog, and basically the court said, no, this basically because of the sharing, you lost the privilege associated with the client. Now, another thing is social media websites have been used and become like in a legal fraternity, indisciple tools. And the nature of social media typically allow not only the lawyers but also the third parties to make a comment about that. So this is very vigilant. They need to be very vigilant, the lawyers, about that, because if someone is putting some information which is inaccurate, this might violate the rule under the Australian solicitor conduct rules. So the information should be accurate and not misleading at all. Okay, that's all. So in nutshell, what we have discovered today is basically this is a very important thing to use the technology for the lawyers, but at the same time, they need to be vigilant. They need to be aware. They should have the skills, knowledge, uh, to understand that what could be the if we don't use it properly, what could be the consequences of as well. Thank you very much for listening. Here are some of the reference being used. It's not the complete list, but this is some of the important one. Thank you very much for